about 8 weeks. Here with me now in the studio, National Security Attorney Bradley Moss, Jamil Jaffer, who was Associate White House Counsel to President George W. Bush, and Marcus Childress, who was Investigative Counsel to the January 6th Committee. I'm so glad you're all with me here today. First of all, we'll take the history dates aside for a moment. March 4th of 2024 is not 2026, okay? It's very obvious, but it's a very soon date considering the fact that, look, you've got 4 trials. This is one that's maybe the most consequential. I want to begin with you because you were on the January 6th Investigative Counsel Committee, and that notion, the fact it's going to be March 4th, before Release Super Tuesday, before a general election, is that the right call from this judge?
Look, I think from the very beginning, the special counsel set the tone that we're doing a pretty tight indictment here to try to get to trial fast. And you saw the prosecutors, again, repeating this notion of we've provided the documents and actually identified for them for you in a way that you can see exactly how we substantiate our indictment. So try to get the trial there fast. And so I'm not going to say it's the right or wrong decision, but it allows the court to have a little bit of slip to the left. Right? If there are pretrial motions that the Trump team may file, it allows a little bit of time and delay and still have this trial maybe in June or July with the busy calendar ahead.
Slip to the left, you don't mean politics. You just mean the idea of having a little bit of move. Right? I'm going to clarify.
Correct. Thank you.
That was a colloquialism. He didn't mean it like that. Okay, everyone, calm down. It was, I see you. Thank you very much. But thinking about the room you'd have to move, you know what Trump is saying? Election interference, not from his own allegations, but instead he's saying, Bradley, this is the judge trying to interfere with an election, and she doesn't care about his campaign schedule. I mean, there are others who have had to prioritize a court hearing over their personal lives. What do you say about that argument to a judge that you are committing election interference, Your Honor, if you don't have the trial date after the general election?
Let me know when they slap on the cuffs would be my response. Because let's be honest, if the indictment came now and the trial happens in 2024, he's going to claim it's election interference. If he loses in 24 and runs again, he's going to claim any trial then would be election interference. Any prosecution of this man, in his view, is election interference because nobody is ever allowed to prosecute Donald Trump. No one's ever allowed to hold accountable Donald Trump. The only people who can hold him accountable is himself, and no one else is permitted. The idea of holding this in 2026 was preposterous. The judge saw right through that. She still gave him more time, which I thought was sufficient. I thought was reasonable. I thought the government was moving way too quickly on that one to do January. Wasn't enough time with pretrial motions. You know those are going to get appealed either way. Putting it in March gives you some buffer room. I still think it gets actually pushed to the end of the summer at this point because I almost am certain we're going to have appellate litigation in this. But I think it was a reasonable compromise given what is essentially a very straightforward case.
I mean, summer still, of course, not the election, and that was the October surprise. I wonder if we'll get to that point. I want to tell you, Jamil, there was a moment that the attorney, John Laurel, who you all have heard from before, says he doesn't have enough time to get up to speed here. And tell you here's what the judge said. She pushed back, saying any agent, diligent, zealous defense lawyer would not have been sitting on their hands waiting for an indictment. Is she right?
Absolutely. I mean, look, he should have been prepping for a long time. The defendant himself should have had counsel. They should have been prepped. There's no question she's right about that. The problem with setting this trial date, even if it moves back to the summertime, it plays right into Donald Trump's hands. He's going to keep saying election interference. He's going to keep saying, I'm off the campaign trail. I can't campaign effectively. This is a Democrat-appointed judge trying to prevent me from succeeding in my campaign for the presidency. And this is the challenge, right? When the Justice Department brings a charge, the president who oversees the Justice Department is running for re-election, right? This would be a whole different prosecution if Joe Biden weren't running for president, if Donald Trump weren't running for president, and we're literally right in the heart of the primary and eventually the general election season.
And yet there have been many who look at this and say, well, the reason you announced your candidacy, Mr. Trump, was because you were not necessarily running towards the presidency. You were running from an indictment. Now, we can quibble whether that's true or not. Some say he's walking to the presidency more than he's running to the presidency. Again, we can quibble about that. But at the end of the day, when you look at this and think of the consequential nature of this, right? This is somebody who, in the January 6th committee, from Liz Cheney to Adam Kinzinger to Jamie Raskin to and beyond, it was about an ongoing threat. There is an election, as we know in a democracy, that's right around the corner. The fact that he is saying, look, this is a politicization of what's happening. Are you buying that based on your experience of what you saw with the January 6th committee?
So a quote that always stood out for me from the members of Mr. Kinzinger, Ms. Cheney, and others, even Mr. Thompson, saying that laws are just words on paper unless those who are elected actually carry them out and enforce them and follow them, right? And so I think that's what this whole investigation has been about, is making sure that our elected officials actually enforce and follow the laws that are on the books, because that's the key to a democracy.
It's also the actual marching orders of the head of the executive branch of government, right? I mean, it's to enforce the laws. But think about this. I mean, March 4th, by the way, is just but one of the many cases that he has, including civil. We're going to talk about more about that. But when you look at the references that are being made to the prosecution, and frankly, did I read that he had about $7 million that he was able to fundraise off of the indictments?
Just off that photograph.
Just off of the photograph
crazy photo
alone. I mean, that's really telling to me. Is it for you as well about how this might impact how he continues with the defense? Because he's not saying, I didn't do it. He's just saying, yeah, I did it.
Yeah.
Next.
No, to the contrary, he's actually succeeding with his base. This is going to draw his base out to vote. In an election where turnout is going to matter a ton, right? He's getting his base out to vote every single day this trial goes forward. He's raising more money. This is bad politically for the Biden administration. It's a winner for Trump. It helps him win re-election. That's a disaster for anybody who thinks Donald Trump ought to be in jail.
As they say, but wait, there's more, because Georgia is on our mind as well. Shout out to Ray Charles. And thinking about, we already talked about Sam Cooke. Why not add him into the mix? Let me ask you, the Georgia is now, the Georgia Fulton County case. There was a hearing today involving Mark Meadows, involving Raffensperger, right? The infamous phone call, a fact-finding inquiry about whether or not to move that case into the District Court of Georgia, expanding, of course, the jury pool based on the fact that Mark Meadows says, look, I thought this was part of my job. What's your reaction?
The devil went down to Georgia and he found out as White House Chief of Staff, he can do just about anything. It doesn't matter if there's no law on the books. It doesn't matter if there's no policy. I'm just the gatekeeper for the president. He wants to make phone calls about things that have nothing to do with the presidency, but have to do with him as a candidate. I'm just doing my work as a federal employee. It would be a complete evisceration of the entire idea of what is and is not your role as a federal officer. He was the White House Chief of Staff. He had any number of responsibilities to serve the president in that capacity. Nothing tied to the campaign would have been within that scope. Nothing tied to campaign litigation would have been within that scope. The federal government, the executive branch, is deliberately excluded from these parts of the process of deciding who won the presidency. There was no role for the White House there.
I was going to say, I was just happy that Mark Meadows testified today. I mean, that's something we didn't get on the January 6th committee. But going back to the evidentiary hearing, this wasn't really an issue of fact. It was an issue of interpretation of law, right? You have the Mark Meadows team on one side saying that there's broad powers and broad scope within the official duties of chief of staff. And then you have the prosecutor saying that it was a political call, right, through Secretary Raffensperger. So it's going to come down to how the court interprets and draws a line of what's an official duty versus a political act, and whether the court actually does draw that line for the removal action. But there was no real issue or genuine issue of fact here. It's just going to be how the court interprets the law.
Well, the court did not rule today. It's not necessarily a frivolous, but whether it be a successful claim, we'll have to wait and see. Look at this, the beginning of a joke right now. 4 lawyers walk into the studio. Okay, Bradley Moss, Jamil Jaffer, Marcus Childress, thank you, everyone. Look, we're never